I'll go. Is it a possibility, let's say you have an agency that is, I don't know, pick a number, 85% is judicial, some of the judicial entities that have been talked about in the briefs, and a smaller percentage is some executive function that they do, whether it's issuing rules or whatever. Is there a principle that you would sever out the smaller little tail on the dog and allow the judicial functions to go on?
Quite possibly, that would be I think a unique severability question that would be distinct from the merits. So if there was an agency that kind of straddles the line between two branches, and that may raise a different severability question. But for the mine run of these multi-member executive agencies, they're clearly exercising executive power. They're doing stuff that the NLRB does, that the MSPB does.
So how about those two? So you are here saying the NLRB goes down, the MSPB goes down, notwithstanding that they do all their work, or almost all their work, in judicial-type proceedings.
I wouldn't say goes down. I would say they were restored to democratic accountability and the constitutional structure. But we have contended on the
current versions of those agencies goes down.
We have challenged those in this court, NLRB and MSPB, and there are others. This court in state law. I mean, there's various lists out there.
How about inferior officers?
We haven't challenged any restrictions on inferior officers.
Why wouldn't that also have to go?
That would certainly, restrictions on inferior officers of the United States would be problematic because, of course, Meyer is involved in inferior officer.
Right.
The logic of Myers extends to inferior officers.
And obviously, there are all kinds of inferior officers wielding executive power all over the place, yeah?
There are many.
Yeah, so it seems as though executive officers. How about employees?
Again, we haven't challenged the restrictions on
I know you haven't challenged it. It's really, the question is, where does this lead? What does it take you to, given what your primary rationale is? Employees are wielding executive power all over the place, and yet we've had civil service laws that give them substantial protection from removal for over a century. How about those?
Well, we do not challenge.
I know what you don't challenge. You're missing the point.
Well, then let me point the court to, if I could, to 7511B, of the civil service laws, the CSRA that we cite in our brief. That is a series of exceptions in it that provides no judicial relief at all to classes of employees, they're called. Now, some of those employees are clearly officers, some aren't, but for example, presidentially appointed officers, Senate-confirmed officials, those who exercise substantial policymaking or have confidential responsibilities, and members of the CIA, for employees of the CIA and the Foreign Service. So there's already been the political branches have in many ways already addressed issues with employees. Now, this court obviously dealt with the employee issue in Lucia, and there was a dispute about that, various, proposed lines between employee and inferior officer.